a todos. La Comisión Interamericana de Derechos Humanos les da la bienvenida a la audiencia sobre medidas acerca de la trata de personas en Estados Unidos. Me acompañan en la mesa la vicepresidenta primera, Tracy Robinson, y relatora para Estados Unidos, y también el comisionado expresidente Felipe González, relator para migrantes y otras formas de movilidad humana, y el comisionado Rodrigo Escobar. Le damos la bienvenida también tanto a la digna representación de las organizaciones peticionarias, Freedom Network USA, y así como a la digna delegación de los ilustres Estados Unidos de América. Tiene el uso de la palabra la representación de las peticionarias por un espacio de 20 minutos.
Good morning, members of the Commission and government partners. My name is Flory Burke, and I'm here as founder of the Freedom Network, representing Freedom Network USA. It's an honor to be here representing them and testifying before you today. The Freedom Network USA is a national network of legal and social service providers brought together in early 2001 by our shared philosophy of a human rights framework and a survivor-centered approach. The Freedom Network has always defined itself by these principles. We take the term human rights seriously, not as a label to add to our name, but as a core principle that guides our practices. We are engaged in approaches that are strengths-based, grounded in personal agency, choice, and resilience, as contrasted with approaches that are fear-based, rely on rescue, and a deficit model of care that looks at victims as weak and helpless. Our members have worked with over 3,000 survivors of human trafficking. We are convinced that education based on direct experience with cases, with survivors, with task forces, etc., is the best way to increase the capacity of those who respond to cases of human trafficking. The U.S. government has trained prosecutors, FBI agents, ICE agents, among others, to identify victims of trafficking. We believe these trainings are most effective when conducted by a multidisciplinary team and must include NGOs and place the rights of survivors at the center. As the first U.S.-based network of providers, the Freedom Network has seen the evolution of the government response to this issue. Many of the early challenges faced by NGOs have been diminished, particularly during the Obama administration. Lack of a coordinated federal response is hopefully a thing of the past, and we all look forward to implementation of the first ever federal strategic action plan developed by the President's Interagency Task Force to monitor and combat human trafficking in persons. The U.S. government has responded to both the criminal justice and victim services systems and to immigration relief out of Department of Homeland Security. The Freedom Network remains concerned about the underutilization of continued presence in certain locales and the low number of T visas issued. The temporary provision of continued presence for those victims that cooperate with law enforcement is a lifeline. It enables victims to reclaim a sense of self-worth, to access certain benefits, and to obtain a work permit. All these provisions help someone move from slavery to independence. Without continued presence, it is difficult to provide assistance to victims or to keep track of them as witnesses. The U.S. government tends to measure effectiveness in efforts to stem human trafficking by the number of prosecutions each year. But the Freedom Network members think that if a true rights-based approach were used, victims would be stabilized, provided necessary services, and given more time to decide about law enforcement cooperation. When this happens, the rate of cooperation is much higher, and ultimately there will be more prosecutions. The Freedom Network applauds the efforts of federal agencies to include NGOs in substantive discussions at all levels. The Blue Campaign of Department of Homeland Security has helped to further the dialogue on immigration concerns, remedies, and future efforts. The Freedom Network proposes to see more integrated training practices so that such procedures as detaining victims of trafficking or deporting undocumented workers without a proper screening for human trafficking do not occur. At a minimum, U.S. victims of human trafficking should not be detained in immigration or criminal detention centers, should have access to counsel to assess immigration, civil, and criminal legal concerns, should have access to social services to address basic needs as well as to assist in addressing the impact of the slavery, and should have access to protections that will assist victims who wish to cooperate with law enforcement. Restitution is a form of justice for victims of human trafficking who often work long hours for days, weeks, months, even years, for little or no pay. Under our federal law, criminal restitution is mandatory, and victims are required to receive an order for back wages in forced labor cases. Those victims forced into the sex industry are entitled to the profits made by their traffickers. In many cases, courts have awarded restitution, but Freedom Network members see little collection of these orders and almost no tracking of payment. Payment and follow-through would do much to advance the independence of survivors. NGOs do not have the necessary resources to make up for this debt or to facilitate true economic independence. Freedom Network members have worked with many cases of forced labor over the years, including trafficking of agricultural workers, domestic workers, hospitality industry workers, factory workers, etc. Many of these involved abusive labor brokers from other countries. The workers arrive with large debts and false promises. Their immigration status is tied to their employer, who is often working in concert with the recruiter. There are many of these cases, but few criminal prosecutions. One exception to be commended is the success of the Asgharo Jayev case out of Kansas City, the first human trafficking case to be prosecuted under the RICO Act. Because Freedom Network members report seeing a higher number of labor cases than those involving the sex industry, threats of abuse of the legal system, blackmail, and threats to victims and their families. The TVPA is supposed to be a victim-centered law, and the Freedom Network is concerned about the bifurcation of labor and sex, of positioning one as more egregious than the other, and of failure to consider that boys, girls, men, women, and transgender individuals may be victims of this crime. The Freedom Network raises the issue of state prosecution efforts because of the negative effects of some state laws on the rights of trafficked persons. Do you think I'm too far away? Okay. Victim protections and services are not included in many of the laws, and as a result, we see that the rights of trafficked people are being violated by the state criminal justice system. The federal government should serve as a model for advancing victim rights and be a resource for states. As federal agencies continue to do trainings for law enforcement, the Freedom Network proposes that the same federal victim-centered practices be incorporated into state policies and practices. In closing, the Freedom Network would like to commend the U.S. government for its own evaluation of efforts to address human trafficking, as noted in the annual TIP report. Challenges as well as successes are noted, collaborative efforts are stressed, and gaps are recognized. This complex crime requires a coordinated response, and there has been significant progress in that direction. We look forward to continuing and expanding our partnerships. Thank you.
Good morning. My name is Zipporah Mazengo, and dear Commissioner and representative of the United States government. It is my honor to be before the Inter-American Commission of Human Rights. I am a citizen of Tanzania. I was trafficked to the United States by the Tanzanian diplomat and his wife. The diplomat, Alan Mzengi, promised me a job in his house and as a domestic worker. I have a contract. My contract promised me 40 hours of a week, $90 per month. Yeah, they promised me 40 hours of a week, $900 per month, $900 a month. I graduated 2 days off each week and 2 weeks of paid vacation. I presented this contract to the U.S. Embassy in Tanzania, and I received a special visa, an A3 visa, that allowed me to come to the United States, legal to work. I was 20 years old. When I arrived in the United States, nothing was as promised. Mr. Mzengi seized my passport and document immediately after I arrived. For the next 4 years, I was held in forced labor. I work around the clock, usually from 6 to 11. My employer's baby sleep in my room. I care for him through the night. I cook, iron, care for the children, and prepare food for the Mzengi's commercial catering business. I clean the Mzengi's 6-bedroom, 4-bathroom house. I rake the leaves and shovel the snow. In 4 years of work for this employee, I was never paid. When I developed medical problem, I was not provided with medical care. When my medical condition became so painful that I could not walk or wear shoes, Mr. Mzengi sent me outdoor to shovel snow. I did so barefoot. The Mzengi took me to the doctor only after 3 years. I had surgery to correct the problem with my feet. I was forced to work on the day of my surgery after returning to the house. In August 2004, I escaped the Mzengi's house with the help of Good Samaritan. I reported the crime to the United States Department of Justice. The Department of Justice did not prosecute my case. Mr. Mzengi continued to work at the Embassy of Tanzania as nothing had happened. My story is not unusual. Many domestic workers are trafficked to the United States by diplomats and employees of international organizations. I was one of the lucky ones. I found a wonderful lawyer, Miss Elizabeth Keys, at a local non-government organization. Miss Keys won a T visa for me, and she found pro bono lawyer for me to file a civil case against Mr. and Mrs. Mzengi. I filed my lawsuit in 2007. The defendants refused to answer the lawsuit, claiming diplomat's immunity. The court's decision be found in your binder at tab G. The court issues a final order requiring that my employee pay $1,059,348.79 in back wages and other damages. That order be found in your binder at tab H. The U.S. government has taken important steps to try to prevent the trafficking because abuse that suffered in this country. But we still do not accountability for abuse that have already occurred. My attorney has requested assistance from the U.S. Department of State in resolving my case and ending impunity for diplomats who engaged in trafficking on the U.S. soil. I am greatly appreciating of all the effort that the U.S. Department of State has made on my case. I believe that the U.S. government take my case very seriously, and I thank the State Department on behalf of victims like me for engaging with the NGOs and advocates who are fighting for us. It has been almost 9 years since I escaped my traffickers. It has been 5 years since the court entered judgment in my favor, but I'm still waiting for justice. In 2008, Congress changed U.S. law to require the suspensions of countries from the A3 visa, the A3 special visa. If the diplomatic mission has one case of abuse and the mission has tolerated the abuse, the law may be found at tab 1 in your binder. My case in the textbook example of a diplomat mission tolerating the abuse, and yet Tanzania has not been suspended from the diplomat A3 visa program. The U.S. government has not suspended a single country from the A3 visa program. I am grateful for all the assistance that the U.S. government provides to trafficking victims. I received a T visa to remain in the United States. I am now permanent resident. I receive assistance from non-governmental organization founded by the federal government. But I respectfully request that countries such as Tanzania that tolerate the abuse or domestic workers by state officials posted in the United States be suspended from the bringing additional domestic worker to this country. I also ask that the United States, an example for all nations around the world, and prosecute diplomats who are engaged in human trafficking, including United States who engaged in trafficking while posted abroad. Thank you very much.
Good morning, Honourable Commissioners, representatives of the US Government. My name is Stephen Watt, and I'm a Senior Staff Attorney with the American Civil Liberties Union. And I'm here this morning to provide the Commission with information on trafficking and forced labour of so-called third country nationals on US government contracts overseas. The United States has long acknowledged that the problem of human trafficking is one of crisis proportions, and that it takes place both inside and outside the United States. Over the past several years, the US has adopted laws and policies to eradicate trafficking wherever and however it occurs, including, importantly, the Trafficking Victims Protection Act. The United States has also publicly stated that it has a zero-tolerance, one-strike approach to human trafficking, But despite these laws and policies and this approach, since 2003, numerous media and government reports have documented the ongoing and pervasive trafficking in forced labour of foreign workers hired to work on government contracts in Iraq, Afghanistan and elsewhere. In 2011, concerned in particular by media reports of trafficking in forced labour on US military bases in Iraq and Afghanistan, together with the Yale Law School, the ACLU began an investigation on the issue. And in June 2012, we published a report of our findings, Victims of Complacency, which you'll find at tab J in your binder. This report documents that since 2003, thousands of foreign workers, known as third country nationals or TCNs, have been subjected to trafficking and forced labour by companies contracted by the government to provide services such as catering, cleaning and construction to the US military and state departments in Iraq, Afghanistan and other countries overseas. Importantly, the report also documents the failure to date of the government to prevent these abuses by effectively overseeing the contracting process, by investigating allegations and prosecuting and punishing the perpetrators. So who are third country nationals? They come mainly from developing countries such as India, the Philippines, Nepal and Uganda. They're contracted to perform low-paid but essential services such as cooking, cleaning, construction and security on US bases or State Department facilities around the world. In 2011, there were more than 60,000 TCNs contracted to work in Iraq and Afghanistan alone. Trafficking in forced labour of TCNs is facilitated by companies contracted by the government exploiting third country nationals' precarious financial situations and the contracting and subcontracting process itself. The circumstances are complicated, but they're detailed in the Victims of Complacency report and also in a handout that I provided to the Commissioners and to the Government before this hearing. But in short, third country nationals are duped into taking low-paid jobs in dangerous countries such as Afghanistan and Iraq, where they are held in a situation of debt bondage. And in other words, they're victims of trafficking and forced labour. As the report documents, since 2003, the trafficking and forced labour of TCNs in this way has been pervasive and ongoing. Potentially thousands of TCNs have suffered this fate, yet in the past 10 years, the government has failed to prosecute one single contractor for their involvement in trafficking and forced labour. Allegations of abuse haven't even been effectively investigated. Documents produced by the government in a case filed by the ACLU to compel the release of documentation on the government's policies and practices of trafficking and forced labour in Iraq and Afghanistan reveal that while some investigations into trafficking and forced labour have been initiated, they have all been closed, primarily because of a lack of understanding of the elements of the crimes of trafficking and forced labour and due to the logistical difficulties of such investigations. Last year, however, the government took some important steps towards addressing this situation and ending trafficking on government contracts overseas. On September the 25th, the President signed an executive order specifically addressing the issues. Among other important provisions, the order prohibits recruitment fees and places responsibility on contractors to ensure that its subcontractors comply with US anti-trafficking measures. The order also requires that government officers tasked with overseeing and contracting process are trained to identify trafficking and enforce anti-trafficking provisions. More recently, on January the 2nd, 2013, the President signed into law the National Defence Authorisation Act, which contains an entire chapter which largely mirrors the provisions of the executive order. This legislation, together with the executive order, are important first steps to ending trafficking on government overseas contracts. Together, they improve oversight of the contracting process and allow for more effective enforcement of anti-trafficking laws and policies. However, they will only achieve their objectives if properly implemented. And in this regard, we welcome and are encouraged by the consultation process that the government has recently embarked upon with a view to ensuring meaningful implementation of the executive order and legislation. There's just one point, last point.
Just 1 minute,
yes.
Please.
We hope that these positive steps signal a more robust commitment by the government to ending human trafficking on government overseas contracts and that moving forward the government will also fully and effectively investigate and, where appropriate, prosecute all instances of such abuse. Only then will the government's zero tolerance on trafficking become a reality for TCNs working for the government and for the American public. Thank you, Commissioners.
Muchas gracias de las peticionarias por su presentación y por el importante testimonio que nos han brindado. Tiene la palabra la delegación de los Estados Unidos, la embajadora Carmen Lomelín, por favor.
Muy buenos días. Good morning, distinguished commissioners, petitioners, representatives of civil society, and secretariat colleagues. My name is Carmen Lomelín. I am the permanent representative of the United States Mission to the Organization of American States. My delegation is pleased to be here today to discuss how our government is making progress against modern slavery. And I would like to take the opportunity to introduce our distinguished experts on this matter. We have Ambassador Luis C. de Baca, Director of the Office to Monitor and Combat Trafficking in Persons, U.S. Department of State. Deputy Assistant Attorney General Roy Austin from the Civil Rights Division, U.S. Department of Justice. Dr. Gabriela Lemus, Senior Advisor to the Secretary and Director of the Office of Public Engagement, U.S. Department of Labor. Judge Alice Hill, Senior Counselor to the Secretary, U.S. Department of Homeland Security. And last but not least, General Counsel David Lopez of the Equal Employment Opportunity Commission. I will now turn the floor over to my colleagues. Ambassador de Baca.
Thank you, Madam Ambassador, and good morning, Mr. President, members of the Commission. Thank you for the opportunity to speak today about some of the United States activities in a burden which is shared by all governments, not just in the hemisphere, but around the world, and that is the fight against slavery and involuntary servitude in the modern era. We do not use this term lightly, but President Obama has reaffirmed the U.S. government's commitment to fight this scourge anywhere and everywhere by its true name, modern slavery. The United States addresses this global challenge with a whole-of-government approach. I'm honored to have been appointed by the President to carry out coordinating efforts mandated by our anti-trafficking law. Across the governments, U.S. officials are working together to confront the traffickers and help their victims, and you'll hear from some of these colleagues today. On Friday, we submitted a more fulsome summary of the United States government's efforts. This morning, however, I won't talk very much about the interagency process, but rather will briefly set forth some of the efforts specific to the Department of State. One of our most important diplomatic tools is the annual Trafficking in Persons report, which has for a decade enhanced a global understanding of this crime. Importantly, the inclusion of the United States in the recent years shows the world that we will hold ourselves to the same standards as everyone else. Our foreign assistance programs as well, which prioritize victim protection, also help us to learn and disseminate best practices such as the victim care and collaborative task force model that empowers survivors, as the petitioners have suggested. I'd like to address in more detail the Department's work to protect the domestic workers employed by foreign diplomats here in the United States, about which we have heard. Whether in the United States or other nations, when an accredited diplomat has exploited a domestic worker, it may be difficult to hold them accountable because of the immunities that they enjoy under international law. In most cases, diplomats are protected not just from arrest and prosecution, but also from civil lawsuits. While there are some differences based on the type of posting and what residual effect their service may carry, without a waiver from the sending state, an accredited diplomat cannot typically be prosecuted, and generally, courts must dismiss civil suits as well. Despite these challenges, progress is being made. We've worked with like-minded countries, which host large diplomatic corps, to identify best practices. We've encouraged multilateral bodies and academics to elevate this issue, and we've brought in the diplomatic corps here in Washington and will in New York to be able to communicate the new policies and structures here in the United States. Over the last 4 years, we've instituted a number of significant measures, and we continue to implement policies aimed at protecting these particularly vulnerable workers. Because, as Secretary Kerry has said, slavery, whether in the United States or abroad, must be recognized, rejected, and eliminated. That's why the State Department's Bureau of Diplomatic Security has established a new human trafficking investigations unit. With the department's full support, these agents are dedicated to investigating allegations of abuse or trafficking by diplomats. We're also helping foreign workers by providing them at the time of their visa interviews with a pamphlet that explains their rights and how they can report abuse when they're in the United States. This brochure was produced in concert with our NGO partners, including the Freedom Network, and we're committed to working with them to continue to inform, protect, and obtain justice for these vulnerable communities. So too, we've responded to the concerns over third country nationals raised today by the ACLU, not only by enhanced training, but by revising the State Department's procurement policies, by coordinating the development of the executive order and its implementation. And we'd like to thank all of our partners from the interagency, especially the Department of Homeland Security and Department of Defense, which chaired the subgroup on our interagency coordinating body that dealt with this. These are just a few efforts to deal with this problem at the Department of State, and I'll ask each of my colleagues to set forth the activities at their agencies. We look forward to any questions you may have.
Thank you for inviting the Department of Justice to address the Inter-American Commission on Human Rights on our work fighting human trafficking. Combating human trafficking by prosecuting traffickers, dismantling and deterring trafficking networks, and protecting and serving the needs of survivors is among the highest priorities for the Department of Justice. As an attorney who has personally prosecuted human trafficking cases, I've had the privilege of partnering with extraordinary law enforcement officers who understand the challenge of these cases and the sensitivity needed. I've worked with incredibly brave survivors who chose to work with the government to seek justice not only for themselves, but for all the children, women, and men who may be vulnerable to human trafficking. And I've worked with the dedicated women and men who belong to non-governmental organizations that focus on eradicating trafficking and improving the lives of survivors. Human trafficking cases are prosecuted by several Department of Justice components, including the Civil Rights Division and its specialized Human Trafficking Prosecution Unit, directed by Hillary Axsom, who is here with me today, the Criminal Division through the Child Exploitation and Obscenity Section, led by Andrew Osterbahn, and the United States Attorney's offices around the country. These cases are investigated by the Federal Bureau of Investigations, the FBI, the Department of Homeland Security's Immigration and Customs Enforcement, and Homeland Security investigators, as well as partners at the Departments of Labor and State. The recent reauthorization of the Trafficking Victims Protection Act is a critical tool in facilitating the sustained commitment of the Department of Justice to bring traffickers to justice and restoring the rights and dignity of human trafficking survivors. The Department of Justice's Civil Rights Division, along with its U.S. attorney partners, has made tremendous strides in combating human trafficking, assisting the survivors, and vigorously prosecuting its perpetrators. Results in recent years have demonstrated unprecedented success in fighting both labor and sex trafficking. We are bringing a record number of federal cases at the same time that more states than ever have passed their own anti-trafficking laws. In the past 4 fiscal years, from 2009 through 2012, the Civil Rights Division and the U.S. Attorney's offices around this country have brought a total of 194 human trafficking cases, compared with 139 over the prior 4-year period, an increase of just under 40%. The increase has been even more pronounced in labor trafficking cases. Over the past 4 fiscal years, we have brought 94 labor trafficking cases compared to only 43 such cases over the previous 4 years, an increase of over 115%. We have enhanced our partnership with the Departments of Labor and Homeland Security, collaborating with them through the Federal Enforcement Working Group to bring joint investigations through our pilot anti-trafficking coordination teams, or ACT teams. Through these partnerships, we have successfully prosecuted domestic servitude cases in jurisdictions where they had never been federally prosecuted before, and have initiated complex, multi-jurisdictional, and international labor trafficking investigations. Now, working with our federal, state, local, and international law enforcement agencies, we have recently secured the longest sentence ever imposed in a forced labor case. In United States versus Botsvanyuk, the lead defendant was sentenced to life imprisonment plus 20 years, and his co-conspirator was sentenced to 20 years for their respective roles in an organized human trafficking scheme that held its victims in forced labor on cleaning crews in and around Philadelphia, Pennsylvania. These defendants lured the victims from Ukraine with false promises of lucrative jobs in the United States, confiscated workers' documents, and used violence, including sexual assaults, and threats against the victims' families to hold the workers in fear, housing them in overcrowded, substandard conditions, and forcing them to work without pay. We have continued to prosecute trafficking offenses, whether they are committed by transnational organized networks, such as Batsvenyuk and United States versus Askarkodyev, where we convicted 8 defendants and dismantled a transnational conspiracy to exploit dozens of guest workers across 14 states, or whether they exploit vulnerable domestic servitude victims in isolation from others. In United States versus Bello, the court sentenced the defendant to over 11 years in prison for holding 2 young Nigerian women in domestic servitude in the Atlanta, Georgia area. In November, a federal jury in Detroit returned guilty verdicts on 4 counts of forced labor against a Michigan man who abused and imprisoned 4 West African children from January 2006 through January 2011, using beatings, sleep deprivation, and withholding of food to compel them to provide domestic service and child care for him and others. In 2012, we secured life sentences against a sex trafficker in Saipan who compelled young Micronesian victims into prostitution, and against a human trafficker in Chicago who lured young, undocumented victims from Ukraine and Belarus and held them in forced labor and forced prostitution in his massage parlors. And we continue to investigate and prosecute these cases to the fullest extent of the law, whether they involve large-scale exploitation of dozens of victims or just a single victim, whether they involve lawfully admitted guest workers, undocumented migrants, or U.S. citizens, and whether they involve children, women, or men. We investigate allegations thoroughly, and we only bring cases when we have the evidence to prove them beyond a reasonable doubt. If at any time we learn that we do not have the required proof, we do what is right for all involved, because the duty of a prosecutor is to seek justice. In addition to our own federal prosecutions, DOJ's grant-making components are funding state and local law enforcement agencies and victim services organizations to support multidisciplinary, victim-centered task forces dedicated to investigating trafficking crimes and providing culturally competent assistance to victims. For example, our Office of Victims of Crime, in partnerships with our Bureau of Justice Assistance, administers the Enhanced Collaborative Model to Combat Human Trafficking Grant Program, to enhance the efforts of law enforcement agencies and victim service organizations in implementing anti-trafficking task forces across the United States. Now, the petitioners mentioned restitution. Recently, we have obtained $200,000 in U.S. versus Cha, a case out of Guam. And we have also obtained $100,000 in restitution for the victims in U.S. v. Arce, a case out of Kentucky. And with respect to the prosecution of diplomats, let me be very clear here. We aggressively prosecute all cases regardless of who the perpetrator is. Now, certainly, as Ambassador Seidabaka noted, there are some limitations to our ability, but we do everything that we can with respect to what we can do and that the law allows. Understanding the impact of trafficking on individuals, their families, and towns and cities across the world brings a sense of urgency to our work at the Department of Justice and strengthens our commitment to continue to enhance our ability to work with our partners to prevent human trafficking and seek justice for trafficking survivors. Thank you.
Good morning. Muy buenos días. Thank you so much. I want to thank the Commission for allowing us to present our views here and for your efforts in the fight against human trafficking. Let me begin by making it clear that the Department of Labor does not investigate or prosecute trafficking in persons. However, the Department does play a key role in the U.S. government's larger anti-trafficking efforts, identifying possible cases in the course of regular labor enforcement work providing employment and training services to victims through our networks of 2,700 American job centers, formerly known as one-stops, and monitoring forced labor and forced child labor overseas, as well as funding technical assistance projects and important research in this area. Of greatest relevance to the issues before the Commission is the work of our Wage and Hour Division, which enforces numerous laws and regulations affecting the most vulnerable of workers here in the United States. This includes minimum wage, overtime, child labor protections under the Fair Labor Standards Act, and protections under the Migrant and Seasonal Agricultural Worker Protection Act. Wage and Hour also enforces the worker protections in the H-2A and H-2B agricultural and H-2B non-agricultural temporary non-immigrant worker visa programs. Given its focus on industries and employers that employ low-wage and vulnerable workers, the Wage and Hours Division's more than 1,000 investigators are often the first government authorities to encounter exploitative working conditions that may in some instances rise to the level of human trafficking or labor trafficking. While Wage and Hour does not have the authority to investigate or prosecute human trafficking per se, it does have the ability to detect it, to document what has been detected, and then refer it to the appropriate law enforcement agencies or task forces, and to investigate underlying pay and record-keeping issues related to human trafficking crimes. DOL's Wage and Hour Division actively participates in 36 regional interagency anti-trafficking task forces. These task forces are composed, as you just heard, federal, state, and local law enforcement agency, along with a variety of nonprofits, NGOs, and are typically headed by the U.S. Attorney's Office. And as also mentioned by my colleague at DOJ, Wage and Hour began collaborating with the Department of Justice in cooperation with the Department of Homeland Security and in the 6 anti-trafficking coordination teams, which are these ACT teams, and select pilot districts around the country. Wage and Hour Division's primary role in these interagency efforts is to assist the law enforcement agencies that are developing and prosecuting human trafficking cases. For example, Wage and Hour may be asked to compute back wages and liquidated damages for the victims, review the employer's records, and provide needed language skills. And just so you know, we have over 600 Wage and Hour investigators who speak at least one other language other than English. I should also note that the Department of Labor's Office of the Inspector General investigates fraud and abuse related to the Department's foreign labor certification programs, as well as non-traditional organized crime threats that may jeopardize the integrity of these programs. They also participate alongside Wage and Hour investigators in the federal ACT teams. Former Secretary of Labor Hilda Solis delegated authority to us, to the department, to certify U-Visa applications to the Wage and Hour Division. As a result, Wage and Hour established protocols and created a position in each of its 5 regional offices to review and, when appropriate, recommend certification of U-Visa applications. Trafficking crimes are among those that are qualifying criminal activities for which the agency may certify a U-Visa application. I want to thank you for your time this morning. Muchísimas gracias. I sincerely hope that this information presented here has made clear the level of commitment that the U.S. Department of Labor and the federal government have in combating human trafficking in this country. Thank you. And in the world. Go ahead.
Buenos dias. I would like to thank the Commission for giving us the opportunity to discuss this important topic. As part of my role as Senior Counselor to Secretary Napolitano at the Department of Homeland Security, I serve as Chair of the Department's Blue Campaign to combat human trafficking. The components of DHS combat human trafficking through a variety of programs and policies, and the Blue Campaign coordinates and unites this work. DHS has the authority to conduct criminal investigations of human trafficking and to provide immigration relief to victims. Given our other mandates, we are also in a uniquely good position to detect human trafficking at our borders, on the seas, and when responding to disasters. DHS believes that victim identification is essential to our efforts. One of the Blue Campaign's first initiatives was to create a web-based training course for state and local law enforcement on human trafficking. DHS has worked diligently to expand the reach of this training. For example, the International Association of Directors of Law Enforcement Standards and Training has made our training available on their web portal for all members. DHS is currently finishing the production of 2 short roll call videos for state and local law enforcement. These videos explain how immigration relief for victims of human trafficking can be beneficial to law enforcement investigations and how that relief may be obtained from the department. Together with the Departments of Justice and Labor, we have developed the ACT teams, which you've heard about. As petitioners noted, multidisciplinary education is particularly powerful, and we have applied that approach with our ACT teams. It trains both investigators and prosecutors together. We will be training for our second round, despite sequester, because of the importance of this topic next week, and it will be a week-long program. DHS has also developed a computer-based training for its own personnel who might encounter human trafficking within their scope of work, as well as training for the federal acquisition workforce. To the petitioner's point, there is a zero-tolerance policy, and in cooperation with the Department of State, prior to the executive order issued by the President, we developed training for the federal acquisition workforce, and the entire workforce within DHS that works on federal contracting has completed that training. We have also worked with Amtrak to develop training for its employees, including the entire Amtrak police force, and we are expanding awareness among other modes of transportation, including new training for airlines operating domestic and international routes to the United States. We provide informational materials to potential victims through domestic embassies, detention facilities, immigration offices, and ports of entry. We also raise general awareness about human trafficking and provide tailored materials for groups likely to encounter victims, for example, first responders. To the points raised by petitioners regarding immigration relief, I will note that we have reached the cap for U visas, the 10,000 cap. For T visas, we are seeing those issued in unprecedented and continually increasing numbers. If petitioners are aware of specific cases where they believe that immigration relief is not being properly provided or accessed by victims, we invite them to bring this to our attention. We welcome the opportunity to learn how we can be more effective in ensuring that victims receive the proper relief. Through its policies, one of DHS's components, Immigration Customs Enforcement, generally seeks to avoid initiating removal proceedings against individuals who are victims of trafficking when they are encountered by ICE and determined to be potentially subject to removal. To petitioners' points regarding screening, I would note that ICE has also completed the nationwide implementation of its risk classification assessment tool in January 2013. This new tool prompts ICE enforcement and removal operations officers to ask detainees for information that might indicate they are a human trafficking victim and flags potential trafficking victims for further investigations by ICE. DHS has the authority to investigate both labor and sex trafficking cases, in addition to the associated violations of employment-based visa fraud and fraud in foreign labor contracting. ICE's Homeland Security's Investigations Office, HSI, conducted more investigations in fiscal year 2012 containing a nexus to human trafficking than ever before, resulting in 894 initiated cases, 381 convictions, and seized assets of over $1 million. In addition, ICE's HSI's global network of 74 offices in 48 countries facilitate forced labor investigations under the Smoot-Hawley Tariff Act of 1930, and the ICE Forced Labor Program is dedicated to investigating allegations of forced child labor as it relates to the manufacturing or harvesting of goods exported to the United States. I look forward to hearing your thoughts and answering your questions. These are but a few samplings of the activities at the Department of Homeland Security combating this most heinous of crimes. Thank you.
Bien, just 2 minutes, please. Just a minute. We are already.
Okay. Mr. President, commissioners, petitioners, it's an honor to be here to discuss the U.S. Equal Employment Opportunities Commission's role in combating human trafficking in the United States. The EEOC is the lead federal agency charged with enforcing U.S. laws prohibiting discrimination in employment on the basis of race, color, national origin, sex, religion, age, disability. Under the leadership of Chair Jacqueline Berrien, the agency issues policy, attempts to resolve charges of discrimination, and enforces the workplace anti-discrimination laws through civil lawsuits. As General Counsel, I was appointed by President Obama to conduct litigation in federal courts nationwide on behalf of the EEOC. Recently, the EEOC adopted a new strategic enforcement plan setting forth the agency's top enforcement priorities. One of the priorities is protecting immigrant, migrant, and other vulnerable workers. The Commission's focus on vulnerable workers is a result of the agency's longstanding work and leadership on behalf of immigrant workers, including the pioneering efforts to apply the anti-discrimination laws to human trafficking cases. As we've heard, a critical focus of the U.S. government's effort to address human trafficking has been the criminal prosecution of traffickers. A criminal conviction may result in the perpetrator having to serve a prison term, but it requires the government to prove the trafficker's guilt beyond a reasonable doubt. The EEOC, by contrast, does not prosecute criminal cases, but instead uses civil lawsuits, in which the burden of proof is the less demanding preponderance of the evidence standards, to seek remedies for trafficking victims who have been discriminated against under our employment discrimination laws. These remedies include lost wages, compensatory damages for emotional distress, and injunctive relief, court orders directing employers to change their policies and practices to bring them into compliance with the law. Let me give you one example, and then I will wrap up. The case of Chelan versus John Pickle involved 52 highly skilled steel workers recruited from India with assurances of lawful wages and appropriate working conditions. They were brought to Oklahoma on B-1 visitor visas. When they arrived in the U.S., however, the employer confiscated their identification and immigration documents, crammed them into warehouse dormitories behind locked company gates with small beds, broken toilets, and no privacy, paid them substantially less than U.S.-born employees, and assigned them kitchen and yard work for company officials. The company owner said, "These are my Indian animals I brought here to work." The Indian workers eventually escaped from the facility with the aid of area churches. As one of the workers stated, "We were told by the company that the Indians were chosen because we come from the part of the world where many people are poor, and that we should be happy and not complain about whatever happened to us." After a trial, the court found violations of U.S. wage and employment discrimination laws and awarded more than $1.3 million in monetary relief to the victims. As the EEOC's chief prosecutor, I stand resolved that no employer should calculate that it can get away with unlawful discrimination based on the belief that its victims will not complain due to cultural barriers. I'd be glad to answer any questions you might have.
Muchas gracias por la presentación que se sirvió a formular la delegación del Estado. Tiene el uso de la palabra la vicepresidenta Tracy Robinson y relatora para Estados Unidos.
Thank you very much, President. First, to express my thanks to the petitioners for bringing this information and the particular presentation you have made. The Commission hasn't had many opportunities on which to hear this kind of information, and your specific focus on labor trafficking is well placed, and we appreciate it. And we also want to recognize and thank the state, and in particular the initiatives which the petitioners themselves have indicated as important ones which you have taken. To the petitioners, I first wanted to just, because we don't know enough about this kind of trafficking, to get a better sense of the profile of and the kinds of persons who are most affected in the context of the United States. So I noted in particular you emphasize diplomats, TCNs, but I was interested in a more general profile. More women than men or not? More children? Is there anything you can tell us in general about who is most affected? And it may be that there isn't any profile. I think the President will give you a chance to respond after. The next question to the state had to do with the interagency coordination. The Department of Labor, Department of Justice, Department of Homeland Security. And I was thinking in particular about the observation that where you, from the Department of Justice, that where you don't have proof beyond a reasonable doubt, then you don't proceed. I wondered whether there were different standards in the different departments to determine who is trafficked and what facilities and services are available. Is the non-prosecution by the Department of Justice determinative of what might happen in relation to other services which are available through the Department of Labor or through the provision of visas and so on? And then the third quick question related to the suspension the petitioners mentioned of the A3 diplomatic visa. Is that correct? And I just wanted a response from the state in relation to that, and whether in the case of the very disturbing incident of the trafficking of evidence which we heard today, whether there was action which could have been taken and wasn't.
Gracias. El comisionado Felipe González, relator para migrantes y otras formas de movilidad humana.
Muchas gracias. Bueno, les agradezco a los peticionarios y al Estado por las presentaciones realizadas. Como señalaba el presidente de la comisión, tengo a mi cargo la relatoría que antiguamente se enfocaba exclusivamente sobre trabajadores migrantes y sus familias y que ahora ha expandido desde el año pasado su mandato para incluir también a desplazados, refugiados, apátridas, personas víctimas de trata y otras formas de movilidad humana. De manera que nos interesa mucho poder mantener abiertos canales de información y de comunicación con ustedes. Tomando el testimonio que prestaba la señora que declaró aquí, yo quería preguntar al Estado en relación con la cuestión de la posibilidad de acceso a un abogado o abogada que tengan las víctimas de trata en Estados Unidos, porque ella explicaba cómo fue en su caso algo circunstancial, fortuito, afortunado para ella, el poder llegar a contar con representación legal, pero que lo más probable es que ello no hubiera ocurrido en otras circunstancias. De manera que ese es un punto que yo quería preguntar al Estado. Y también quisiera pedir información más específica, que puede ser parte aquí, parte después por escrito, entendiendo los constreñimientos del tiempo, respecto de las formas de monitoreo que el Estado está llevando a cabo internamente, o sea, en el territorio de Estados Unidos en relación con las personas víctimas de trata de personas. Hay algunas iniciativas que se han explicado, sería bueno tener un panorama conjunto que, como digo, puede ser también por escrito. Gracias.
Gracias. El comisionado Rodrigo Espora.
En primer lugar, quiero dar un saludo especial tanto a los peticionarios como a los representantes del Estado, reconocer el gran trabajo que se ha realizado por los peticionarios al presentar la información y también la información del Estado, que me parece que está bastante completa. Sin embargo, yo quiero profundizar sobre un punto sobre el cual no hemos recibido información. Entonces me gustaría pedirle información al Estado, que nos la pueden hacer llegar por escrito, pero previos unos comentarios. Tal como lo han dicho los peticionarios, sí se aprecia que ha habido por parte del Estado avances en relación con la investigación y el castigo a los responsables de este delito. También se ve que existe una organización entre las distintas agencias del Estado para investigar y para sancionar a los responsables. Si bien ese esfuerzo es importante, me parece que no es suficiente, por cuanto pues aquí no podemos perder de vista a las víctimas. Y si bien es cierto, hay que castigar a los responsables, también hay que dar una protección muy especial a las víctimas, y en ocasiones los mecanismos judiciales no son suficientes. Se hablaba aquí de varios casos en los cuales a los responsables de la trata se les condena a pagar unas reparaciones, pero también habrán otros casos, o hay muchos casos como el testimonio que vimos hoy, en donde no se van a identificar o no se van a poder condenar a unos responsables a pagar una reparación. Entonces, en relación con ese punto y en general, quisiéramos recibir información sobre los programas y las políticas que tiene el Estado para dar asistencia a las víctimas de la trata, y de si existen algunos programas encaminados a darles ayudas económicas, compensaciones económicas a las víctimas, que si bien el Estado pues no debe darlas a título de una responsabilidad, sí son normales a título de una solidaridad con las víctimas.
Sí, muchas gracias. Sí, efectivamente, en relación con este último aspecto de los programas de reparación que hacia las víctimas, también que las mismas pudieran, en su caso, agradeceríamos la información, si existiera, cuando las propias víctimas son migrantes indocumentados, ¿verdad? Se ejemplificaba un testimonio de que fue con documentos la inmigración, pero también si habría algún programa en este sentido y no exclusivamente caso por la vía judicial. Le solicitaría al Estado si nos pudiera proporcionar información, no ahora seguramente, sino en su oportunidad complementaria. Y también hemos recibido la información estadística que se ha mencionado y que apreciamos, pero también reconoceríamos si se nos hiciera llegar información y ambas partes relacionada, no solo por lo que se trata, o sea, diferenciando lo que es la trata laboral, la trata de personas de carácter laboral de la sexual, también lo que se mencionaba, los casos en que se han procesado y llegado a castigar, ¿verdad? Diferenciando la problemática de uno y otros, y también si acaso hubiese identificado algunos casos en que se haya procesado funcionarios públicos. Tener toda esta información sería altamente apreciada por la Comisión Interamericana. Hemos rebasado el tiempo fijado a la presente audiencia. Va a ser muy bienvenida toda la información que con posterioridad se sirvan presentar por escrito. Toda vez que tenemos un programa de otras audiencias, no podríamos dar en este momento, destinar más de 3 minutos a cada una de las partes.
I think I'll respond to your first question about a profile. There is no profile of who is a victim of trafficking. I think when I started this work in 1997, before we had a law in the United States, and then in subsequent years, we thought that most victims were young women, undereducated, poor, from small towns. We now see that victims of trafficking can be highly educated. The men who were involved in the John Pickle case were highly skilled welders. Some of them were engineers. We've seen nurses, we've seen teachers, and we still see a large number of poor individuals, both men and women. One of our great difficulties is quantifying this crime, counting the victims. It's really difficult to do. So I would say that there is no profile. If you look around the world and you see where there's gender imbalance and where there's lack of opportunity and where there's civil war and where there's economic collapse, we can be sure that we will see victims from those regions. And that's probably the most accurate answer I can give you on that.
Gracias. Tiene la palabra la delegación del Estado.
Thank you, Mr. President. Just a couple of quick answers, and then I think we will submit a number of things for the record afterwards, as each of you have suggested. I do want to address, however, especially in light of the bravery that she's shown in coming today, the case that Ms. Mazengo has mentioned and the question that Commissioner Robinson has raised. The default judgment that was entered against the Tanzanian former diplomat continues to be of significant concern to the State Department, and we've repeatedly advised Foreign Chiefs of Mission that they're responsible for ensuring that their A3 workers are paid in accordance with contracts and the personnel under them pay their just debts. But we also are engaging with the government of Tanzania on this case. We engaged with them when the default judgment was obtained. A settlement offer was made by them. There are continued settlement offers and settlement discussions that hopefully can proceed. To that end, we're again engaging the government of Tanzania to do what's necessary to see that this matter is addressed and have raised this case with high-level Tanzanian officials. So we're continuing to act on this and to bring this attention to the Tanzanian government. One quick answer for Rapporteur Gonzalez's question about victim care, which I think that Mr. Escobar Gil had a question on as well. The victim care programs are with the Department of Health and Human Services. The way that we do victim care in the United States is to reimburse the non-governmental organizations for the things that they're working on. And in recent years, that's been extended to allow for reimbursement for legal services as well as for social services. That was a gap that was hurting, I think, a lot of victims out there. We saw that as something that the non-governmental organizations had realized, that you have to have both legal and social services for the victims, that the two cannot be separated. And so as a result, the Health and Human Services programs now provide for that, as well as the support of the victim services programs at the Justice Department through the Office for Victims of Crime. The information that we'll be sending over as far as victim programs and policies to assist the victims, including compensation, are very fulsome. One thing that's very important, though, as far as being able to get the money in the hands of the victims, is a provision of our law of 2008, which allows the U.S. government to take the money, instead of simply seizing the assets of the criminal, like we would in many cases, a drug case or other things, seizing the assets of the criminal. Usually that money would go to the government. There's now a provision in the United States that allows the government to pay that money out of the Treasury to the victims, especially when there's been a restitution award. And that's something that I know in several cases, including cases of domestic servitude, the Justice Department has been successful in doing. So we as a government are committed to looking at ways to get the victims the restitution, the reparations that they deserve, knowing that it's always hard to follow the money trail in a criminal case. But we look forward to submitting more of this information for the record in written form, and thank you so much for holding this hearing and for allowing us to present today what we think is a record of accomplishment.
Gracias a ustedes, la digna representación de la organización solicitante, y apreciamos mucho su testimonio. Muchas gracias. Y lo mismo también la participación de la digna delegación de los Estados Unidos de América en esta importante audiencia sobre las medidas sobre la trata de personas en Estados Unidos, la Comisión Interamericana de Derechos Humanos mantendrá en su agenda este tema y apreciará cualquier información adicional que se sirvan presentar. Muchas gracias.